On the anniversary of the publication of Benjamin's essay Toward the Critique of Violence, one question in particular demands to be posed, namely, what might the essay still say to us today, 100 years since it first appeared? One way in which one might set about answering this question is, of course, by interrogating whether the context in which Benjamin wrote his essay still persists, or has in fact changed so radically as to demand a transformation of its terms. But the essay itself is not particularly forthcoming in this respect. In fact, a peculiar characteristic of this essay is that it barely refers to contemporaneous events. It only makes one allusion to the doctors' strike, which occurred in early 1919 during the German Revolution, when medical staff refused to treat patients in several cities around the country as a counterstrike against the Spartacist movement. Another peculiar characteristic of the essay is that it also does not refer to any contemporaneous legal or political debates on violence. Benjamin's references, which are Georges Sorel, Erich Unger, Hermann Cohen, and Kurt Hiller, are a heterogeneous group and were, apart from Cohen, relatively unknown. Instead, what markers the essay contains in respect to the afterlife of a significance are manifest in the form of a number of questions it explicitly leaves open. Chief among them is what is supposed to happen after the ending of the philosophy of history of violence, which Benjamin says is to make possible a departure from the apparent dialectic of law positing and law preserving violence. As he writes in the essay's final paragraph, this cycle comprises the state's use of its legal capacities to suppress law-positing counterforces. These are, for instance, the right to strike and the right to self-defense. But it is a self-preserving tendency that sees the law-positing violence that it suppresses intensify to the point of overcoming the authority that had hitherto posited law, upending the relation between them and founding a new law with a new decay. Whatever the breakthrough out of this cycle should look like, and the difficulty of the final line's reference to a waltende Gewalt, or pending violence, that withholds its own expenditure and leaves no new law in its wake, has generated many competing interpretations. Benjamin also gives indications of concerns to which he might one day return. As he writes to Scholem in January 1921 upon completing the essay, quote, "There remain questions concerning violence that it does not touch." And in fact, the essay gives hints of the domains in which these untouched questions of violence might be pursued. To determine whether there were any violent means that are moral, for instance, Benjamin suspended the question concerning a criterion for justness. And the discussion of so-called pre-constitutional relations, such as peace ceremonies, images of individual violence, the death penalty, and unwritten law, was confined to matters pertaining to contemporary Europe. The aim of my presentation is to explore the possibility that Benjamin posed precisely the question concerning a criterion of justice in relationship to matters outside of contemporary Europe as an extension of his 1921 Critique of Violence. To do so, I refer to a piece of archival evidence that, though known to the editors of the Gesammelten Schriften, was never published and is about to appear for the first time in the annotated critical edition that will come out in a couple of months with Stanford University Press. This document is a book list, not unlike others that Benjamin was in the habit of composing for his various projects. But its title alone makes it remarkable: A Literature for a More Fully Developed Critique of Violence and Philosophy of Law. The book list contains items published as late as 1928, and, as the title suggests, includes a vast array of literature one might find in a German law library of the period. Major canonical works representing the most recent developments in positive law and natural law, constitutional law, comparative law, and legal ethnology. Whatever else the book list was meant to convey, at the very least it suggests this: that Benjamin saw something in these fields that would allow him to pursue the question of a criterion of justice in the extra-European domain. And as I will argue, what this something was also promises a breakthrough of the cycle of law positing and law preserving violence that Benjamin sees as characterizing intra-European juridical affairs, a cycle that seemed to him to turn specifically on the state's self-perpetuation by virtue of its capacity to suppress counterforces, such as the right to strike and the right to self-defense, which reserves the possibility for these same forces then to overturn the very authority which suppressed them in order to establish a new law and a new suppression presumed to be necessary for the stabilization and continuity of the rule of law. For as some of the most notable entries in Benjamin's book list argue, state authority is not necessarily equivalent to the rule of law. Relatedly, natural law, where the criterion of justice might be sought, does not exclusively denote the doctrine that we are in possession of naturally given powers that we give up in order to enter the social contract, which is the idea of which Benjamin gives a summary description in the opening paragraphs of Toward the Critique of Violence by way of referring to Spinoza and the revival of Darwinism. Such a view would regard the exercise of violence for natural ends as producing its own source of legitimacy in view of the state, a view that Benjamin rejects as unproductive for the question of whether or not violent means as such are ever justified. In contrast, sometime between 1921 and the latter half of the 1920s, according to the book list, Benjamin immersed himself in the literature pertaining to a rather different debate in regard to the source of law, constitutional legal theory, specifically the debate between Hans Kelsen and Carl Schmitt on constitutional guardianship, which famously culminated in a series of heated exchanges on the respective roles of judicial review and executive authority in the 1930s. Benjamin seems to have been familiar with the publications documenting the run-up to this moment throughout the 1920s. This familiarity suggests above all one thing, that another critique of violence would need to be sought beyond the antinomy of natural and positive law he had constructed in Toward the Critique of Violence, partly on the assumption that natural law is synonymous with rational self-rule, and partly from suspending the question of the justness of ends. Later, instead of regarding the criterion of justness of ends as extrajuridical because it can only be discovered within an antinomy, Benjamin entertained the possibility of another relationship to law, that, while being neither justified law nor the moral idea of law, was also not merely outside the law. There is, in other words, a possible source of law that, being neither logically nor morally derived, reserves the possibility of affirming all existing law regardless of its value, or, as the case may be, suspending law altogether. In other words, around 1927 or 28, natural law designated for Benjamin a realm that its proponents regarded as both eternal and radically subjectivistic. Indeed, this was precisely the charge Hans Kelsen laid against proponents of personal creativity and legal judgment, such as the exercise of conscience, in respect to a debate in 1926 over Article 109 of the Weimar Constitution. It was also the substance of a point he had earlier made in respect to the 1920 Austrian Constitution he had helped draft, a point he elaborated in the article Vom Wesen und Wert der Demokratie, which was published in the same issue of the Archiv für Sozialwissenschaft und Sozialpolitik, where Benjamin's Toward the Critique of Violence appeared. Kelsen argued that turning either to personality or supralegal perspective as the source of the equality of all under the law amounts to a mere assertion of authority against democracy. Indeed, since the social contract relies on the agreement of signatories who are free to withdraw their recognition of its validity at any moment, equality before the law must be a fiction of representation that cannot substantively correlate to the rule of an absolute majority. For actual unanimity would be merely mechanical and lead to autocracy. Instead, the majority principle in democracy must be a hypothetical unanimity, to which correlates proportional representation, which then protects the freedoms of minorities and safeguards their potential to become the majority in turn. The turn to what Kelsen called natural law metaphysics only serves, in Kelsen's view, then, to discover behind legal authority, quote, the Gorgon's head of power. In contrast, and as of course is well known, Carl Schmitt insisted on seeing all law as situational law, the normal everyday frame of life to which law can be factually applied must be acknowledged by the jurist as belonging to law's immanent validity. Against Kelsen's efforts to derive law's authority from a purification of jurisprudence of precisely any moral, political, or ideological influence, Schmitt claimed that legal orders derive from the successful defense of a case against an opposing will, and that forms of government were designed to resolve particular problems. As he writes in Dictatorship from 1921, even 17th century natural legal theorists understood that sovereignty is a question of the decision on the decision, and that equality before the law pits us against an enemy group in mutually defined difference. Benjamin's engagement with Schmitt is, of course, well known. He refers to the importance of Schmitt's political theology for his habilitation thesis on the origin of the German Trauerspiel. But it seems, given the book list, that Benjamin related to Schmitt as Kelsen's antagonist, that is, as the proponent of the thesis that personality is the beginning and end of the constitutional state, and that law, as such, is therefore politics. Against Kelsen's view that we are born into law and must therefore presuppose the first historical norm, as the question of the origin is from the technical normative point of view an extra-juridical consideration, Schmitt represented for Benjamin the position that the democratic principle of equality before the law expresses itself as war of all against all, in the face of which a decision is made on what constitutes normal public order and what does not, everywhere in the form of inexplicable state interventions, and in the manner of which Schmitt calls a, quote, huge cloak and dagger drama. In the light of this understanding of Schmitt's significance for Benjamin's transformation of Schmitt's thesis on sovereign decision is crucial. As he writes, quote, the sovereign represents history. He holds historical occurrence in his hand like a scepter. This conception is based on ideas about constitutional law. That is, in legal theory, as well as in the debate between Kelsen and Schmitt. The 17th century concept of sovereignty, as described by Schmitt, shores up the doctrine that the power to depose a rival lies absolutely with the prince rather than the church. But the result, in Benjamin's account, was a, quote, demand for a principality whose constitutional status guarantees the continuity of the commonweal, a demand that is played out in the arts and in theology, that is, in theory. The sense of being driven toward catastrophe and the need to demand that its political and juridical institutions multiply and blossom in an effort to put a halt to time, these were, for Benjamin, descriptors of a legal theory driven to hyperbolic distraction in its anxiety about its own foreclosure in the inexplicability of the source of law. In Kelsen's terms, this opacity translates into our need to simply presuppose the validity of the first historical norm. Benjamin, in short, reads Schmitt polemically as an aesthetic theory, which he does by taking Schmitt's metaphor of the cloak and dagger drama literally and grappling with an altogether different picture of the source of law as a result. In the origin of the German Trauerspiel, this other source is indicated by the artistic and literary portrayals of the indecisiveness of the tyrant, with whom rests the decision on the state of exception, and who shows that, at the first given situation, resolve is nearly impossible for him. This is because of the sheer arbitrariness that decisionism implies. With actions no longer unquestionably determined by thought, the ruler at the zenith of his power is simultaneously the point where history and power meet and a victim of his own unelevated humanness. The indecisiveness he diagnoses in Schmitt's construction of the tyrant is based on a paradigm that he retrieves from toward the Critique of Violence, according to which the claim that a person suffers absolutely no constraints, quote, merely suspends reflection on the moral historical sphere, and thus on any sense that action might have. That is, without any moral or historical sense to give it direction, reality too is deprived of its sense. And likewise, where there is no sense to action, there can also be no decision. In terms of early modern constitutional theory, it is the tyrant who suspends reflection on the moral historical sphere. Sovereignty thus merely describes the situation where action has no sense and decision is not possible, leaving just execution, implementation, and, indeed, dictatorship. For Schmidt, dictatorship thus refers to any direct exercise of stately power, which may include as its aim saving democracy, though by definition it will not conform to the legal norms of that toward which it is directed. In Schmidt's words, dictatorship is therefore like the act of self-defense, which means that it does not regard the specific technical means of his action as having a binding legal basis that the attacker shares. For Schmidt, dictatorship is a name for the inexplicable state intervention that appears everywhere and in multiple guises as the pre-constitutional act of personality that is ineluctable for the existence of legal norms. For Benjamin, in the first instance, dictatorship therefore reduces itself to a sort of obsession with technicity without a goal. But dictatorship therefore also indicates for Benjamin a decay imminent to its very concept, a decay of the power driving history that distinguishes it from natural law on the one hand, which engenders a world of such sheer arbitrariness that dictatorship seems like nature again on the other. For Benjamin, Schmidt's generalization of pre-legal power thus delivers creation up to one of the most basic pre-constitutional principles of law, the Schuldverhältnis, which can be translated as obligatio, quasi-contract, or literally relation of debt or guilt. Schuldverhältnis underlies all contractual obligations and includes what might be considered its first cousins, the sale of goods, owner-occupier relations, vindication, and restitution. Furthermore, Schuldverhältnis includes the act of self-defense too, which is how Schmidt described dictatorship. Dictatorship, then, would deliver creation to an obligation that it alone, as the expression of the basic impulse to defend one's interests, is in a position to enforce, and in so doing, transmute into law. In other words, dictatorship names the act of self-defense generalized into guilt across creation, and the act of self-defense generalized into guilt across creation is what underlies the transition from one state of law to the next, including from might to right. Benjamin considers the transition of might to right in the example of the death of Socrates in the Tagesspielbuch, whom he describes as going without defiance to his death. In this sense, Socrates thus, unlike the tragic hero, seems to die a sacrificial death that establishes a community in the spirit of a coming justice. For this reason, Benjamin argues, Socrates' death also narrates the myth of transition into modern law, in that, in his willing death, personal redress gives way to a standardized jurisprudence. The implication of this is at least twofold. First, Socrates' conscious and willing meeting with death divides death itself. As Benjamin writes, death thereby becomes salvation, a crisis of death. Second, mourning this death is therefore the state in which we accept death as a penalty meted out justly by law, the state's successful pacification of self-authorized uses of violence for the sake of the rule of law, which in this case would seem to be coextensive with the state. In short, even as it refers to the transition out of myth, Socrates' death mythologizes the transition to the constitutional state, in the light of which the modern state appears as a state of mourning, as a state of conscious ironization of the tragic death that stood for the right to self-defense, the legitimate use of self-authorized violence. And thus, the modern state, the transition into which is mythically represented by Socrates' death, is also revealed to be a mythologization of our having freely relinquished this self-authorization in the name of the rule of law. It follows that the court of law, too, is a setting for our non-defiant submission to the state's monopoly over life and death. Under the assumption shared by Schmidt that the active motive force of history is the generalization of guilt across creation, all relations, including those of constituent power, dictatorship, and self-defense, which after all, one might regard as quasi-synonyms for Schmidt, those are recast in the shape of the transition from might to right. But Benjamin does not merely draw attention to the mythic character of this theory of transition into law. He also thereby removes both personal will and the constitutional courts from consideration as sources of law, or to be precise, he removes from consideration the question of law as the focal point of a transition, be it from power or another law, and so removes the guardianship of law from the end goal of his inquiry. What Benjamin leaves himself with, however, is immense. And this is what I would like to conclude with. He leaves himself with the entire field of Schuldverhältnisse, that is, obligations, quasi-contracts, and debt-guilt relations underlying everything from goods exchange to possession and occupation, vindication, and restitution. These debts and obligations fill a terrain that otherwise appears as a history of commodity exchange and reification of relations that modern capitalism produces in the guise of society's natural laws. At the same time, it is also a terrain that is filled with a, quote, wealth of things, as Benjamin writes, which the Baroque extracts from a beyond, that it empties of everything in which even the faintest breath of world wafts. And this in order to reimagine it as available for extraction work. In Benjamin's words, this wealth constitutes the catalog of Byzantine Orientalism, which provided the Baroque with an ostentation of pure materiality for its plays. From this trove of materials, extracted from extra-European ground, and its world character annihilated, and therefore appearing as dead nature, the Baroque availed itself of materials for its own repurposing into an exaltation of its princes as deities, each one the center of his own solar system. Each prince whose glory is fashioned from the labor of extraction is a sun that cannot countenance the coexistence of another except in the form of a solar eclipse. Each act of extraction that contributes to this cosmology therefore participates in a myth of origination, specifically one whose scope is incompatible with the, quote, constitutional political reason that juridically affixes the sovereign's position on the interior of the state, but is fully in synchrony with the Baroque's, quote, effusive ideal of world domination, which sees each prince ensnared in a perpetual and paranoid struggle with the other, his own shadow. Benjamin makes clear that the two aspects of the prince, the sovereign of the constitution and the aspirant to extraterritorial dominion, are sides of the same allegorical engraving, and that the critique of power, as the principle of mythic law positing, must therefore also critique the violence of origination of that power. As he writes, quote, the Baroque extracts a wealth of things that tend to withdraw from all shaping, and at its zenith brings them to the light of day in drastic shape in order to clear out a last heaven and put it in the position of a vacuum that will one day annihilate the earth with catastrophic violence. As an extension of the monopoly on power over life and death within the sovereign European state, this work of extraction, this colonialism, aspires to erase its own traces and reestablish equilibrium by codifying the pacification of individual, that is, the relinquishment of indigenous exercises of self-defense, in the idealized image Europe has of its own natural legality and constitutional propensity.